Good morning, everybody. This is Jason Kleen. I'm an Assistant Executive Director with the Department of Cannabis Regulation. And today we're going to have a brief Q&A session and discussion about navigating DCR's licensing map. The comms team has put together a PowerPoint presentation, which I'll be navigating back and forth from, and then doing a live interaction on our website and showing you some of the tools that the department utilizes as we put together the information that goes on the licensing map. So today we're going to go through just the welcome and opening. Um, we're going to go through our retail pending locations map versus our licensed retailers map, what the differences are between the two maps and the information displayed, how to navigate our retail and pending locations map, which is also referred to as the DCR licensing map, how to use the different layer features, how to navigate the map of licensed retailers, which is something that we've put together for consumers so that they can find licensed locations and identify general businesses versus social equity businesses. And then we'll hop into a question and answer session. And then our team will share what resources are available to the council offices. If you get any inquiries, you're looking to verify whether or not a location is pending, has a license, or may be engaged in a licensed commercial cannabis activity. So the first map we're going to talk about is the DCR licensing map, which is a tool that we've put together for our applicants and licensees. So if you navigate to the DCR's website and you go under licensing, you'll see that there's a licensing map function there. So that's what you'll click on. We have the general disclaimer about the map is for informational purposes only. The data on the map changes from time to time. You know, folks are responsible for doing their own due diligence before they submit a record to DCR. And then, of course, information submitted to DCR may be subject to public disclosure. The map itself is embedded, and folks can go ahead and zoom in to different areas of the city. The light colors you see on the map are the council boundaries. Um, and then the different pins are locations that create a sensitive use buffer. What I recommend folks do is make the map larger, and then that'll take them into the full viewer of the Google map. So within the Google map, there's a search function up here. So folks can type in an address. And then we also have different layers. So the retail storefront businesses that have temporary approval are the little ones with the shopping bag. Those are the locations that folks can actually go to and purchase cannabis. The retail storefront applications that are pending are the little blue map icons. Those are locations that create the 700-foot sensitive use buffer between other retail storefront businesses, but they do not yet have a license to operate. And then we have other information tied to the sensitive use layers, such as for the retail storefronts, they have to be distanced at least 700 feet away from alcoholism and drug abuse treatment facilities, schools, daycare centers, public parks, public libraries, and permanent supportive housing projects. These layers all apply to the retail storefront activity, and they're updated on a quarterly basis. So folks have the ability to toggle on the information. This information was last pulled on August 1st of 2023. That's the first day of the quarter. It will be updated again next week on November 1st when we pull the next set of quarterly data. So what I'm going to do is I'm going to hop into our internal document that kind of talks about how we do our measurements, what the list of the sensitive uses are. This all comes from Los Angeles Municipal Code Section 105, and it's something that the Department of City Planning is the lead on, and basically DCR just implements based on what was adopted by the mayor and city council. So for distancing purposes between commercial cannabis businesses, it's the horizontal distance measured in a straight line without regard to intervening structures from the closest exterior wall of each business. And, you know, closest exterior wall is important. So if you have like a downtown location where there are shared walls on the sides and in the back, the closest exterior wall may be actually on the sidewalk side where customers come into the business. So if there's not a back alleyway or some other exterior wall at the back of the facility, if another business is located from the back, we're not measuring from the edge of the parcel. We're actually measuring from the exterior wall that may give them the benefit of the closed location because that's where customers come in. So oftentimes with stakeholders, they don't understand how the measurements get done and how we follow the code to implement those measurements. It's not parcel to parcel. It's the closest exterior wall of the commercial cannabis business to whatever we're measuring to. If it's another commercial cannabis business, it's going to be the closest exterior wall to that business. If it's a sensitive use with exclusive use of the parcel, we'll measure from the closest exterior wall of the commercial cannabis business to the closest parcel boundary of the sensitive use. And it's the parcel boundary of the address that is publicly available on the quarterly date. So if the business is engaged on multiple parcels, but only one address is publicly available, we measure to the parcel boundary for the address that that sensitive use is actually located on because that's what's publicly available. And then if between commercial cannabis businesses and sensitive uses without exclusive control of the parcel, it's the closest exterior wall of the commercial cannabis business to the closest exterior wall or fence under the control of the sensitive use. So for instance, on the UCLA campus, they have a couple of daycare facilities that are licensed. The daycare facility doesn't have exclusive control over the entire college campus. Therefore, if we're measuring to that sensitive use, it would be from the closest exterior wall of the commercial cannabis business to the closest exterior wall of the daycare facility located on the UCLA campus. Once we've done our pre-application review, the applicant's record is deemed compliant with the required distancing if the business premises location complies with the required distances from the sensitive uses that are publicly available to the department on the verification date. So once we've made our determination, it's effectively final. Sensitive uses that are not publicly available shall not disqualify an applicant's proposed business premises location. So effectively, if you had a school that only had one publicly available address and it was operating across multiple parcels, and then they reached out to the California Department of Education and expanded their record to include an address range that would then cover multiple parcels, because that information was not publicly available when we pulled the raw data and deemed the location eligible for further processing, it will not disqualify somebody. So if the person that creates the sensitive use decides to modify their information with a state agency or a city agency after we've made our determination, it will have no bearing on the applicant. If a sensitive use comes in after we've made our eligibility determination, it will not disqualify the applicant. And basically, we've made all of these we've already made these determinations for any pending application that is already before the department. And then we make it as we process our pre-application records. So anything that you see as either a temporarily approved location or a pending application on the map has already been deemed to comply with the provisions of LAMC. The application date is the date that the applicant paid all of their pre-application review fees or a modification request to relocate, if that's the case, required under the municipal code. A sensitive use is alcoholism or drug abuse treatment facilities, daycare centers, public libraries, public parks, schools, and permanent supportive housing. And then we get into publicly available. That means that the sensitive use is identified on an official list posted on one of the official websites maintained by the entity who is responsible for issuing those licenses or creating those sensitive uses. and the official list is maintained on DCR's rules and regulations. The verification date is the first business day of the quarter, so February 1st, May 1st, August 1st, November 1st. Those dates were chosen because January 1st of every year is going to be a holiday. Depending on where July falls on the calendar, where the first is, whether it's a Saturday, Sunday, or there's breaks due to the 4th of July holiday, that could change the first business day of that quarter. Therefore, we chose February, May, August, and November to be the starting dates for our verification date because we only have to worry about weekends. We don't have to worry about city holidays or pushing that date beyond a few days into that quarter. Public library, those are basically anything under the control, operation, and management of the city's Board of Library Commissioners. So we pull that data from the data hub that the library department maintains. For permanent supportive housing, that's a two-prong test. So the first prong is it considered a supportive housing project based on the permanent supportive housing ordinance? The second thing is, if it is considered a supportive housing project, do they provide on-site support services? So it could be a supportive housing project, but if it doesn't provide on-site supportive services, it does not rise to the level of being a sensitive use. If the supportive services are provided on an adjacent parcel or off-site, it's not considered permanent supportive housing for the purposes of being a sensitive use for our licensing process. We get the primary data from the housing department's data for affordable housing projects. In order to be considered permanent supportive housing, it's got to be tagged as supportive housing. And then in terms of verifying the on-site services, we also use the housing department's website to see what services are available for that given project if we do our review. For public parks, these are things under either the city, the Santa Monica Conservancy, the county, the state, federal parks. Basically, what we do is we go to the GeoHub, and there's a GIS database of everything that all of the different park facilities within the city. So we're going to be pulling the data from the new GeoHub location starting next week when we pull the next ring of data. For the alcoholism or drug abuse treatment facilities, again, it's got to be licensed or certified by the state of California, and they have to provide residential non-medical services to individuals. So if it's a treatment program tied to a hospital, it's not going to be a sensitive use for our purposes because that's medical treatment, not non-medical treatment. And when we pull the data, we go to the State Department's website and we pull the information, and the facility itself has to be licensed or certified, and they have to provide non-medical residential services. If they don't provide the non-medical residential services, even if it's a licensed drug and alcohol treatment facility, it's not considered a sensitive use. And then for schools, we pull the information from the California Department of Education. It doesn't matter if it's a public school or a private school. If they provide in-person education for the grades K through 12, and they're licensed by the State Board of Education, and they're effectively on their list, it'll be considered a school. Virtual campuses or campuses that don't provide in-person instruction are not considered schools. Junior colleges, universities, vocational professional schools, anything not K to 12 is not considered a school for the purposes of our sensitive uses. We pull the information from the California School Directory. Basically, we filter and export all of the school-related data, and then that allows us to render the layer. The state also has a requirement that retail storefront locations be at least 600 feet away from a school. So our local code is more restrictive. So locations that comply with our local code should comply with the state's requirements as well. And then daycare facilities, this is one I think that council offices get a lot of questions about. So there's three different types of daycare licenses that may be considered a sensitive use. They're the child care infant centers, the child care centers, and the child care center preschools licensed by the state of California Department of Social Services. And the second piece is they can't be located on a residentially zoned property. So there's a number of folks that have gone out and gotten licenses that are not properly permitted at the local level. And we had a situation in 2018 where the council office, notified us that a daycare facility may be too close to an existing medical marijuana dispensary. And they had a commercial license, but the commercial license was tied to a single family home, and they didn't have the necessary permits at the local level. So when it was referred to DCR for review, we sent it over to the Department of Building and Safety because they were not properly permitted with the city, and Building and Safety took an enforcement action against the location and basically shut them down. So the commercial cannabis business was still able to move forward. And then there was an enforcement action taken against the licensed non-permitted daycare facility, which upset the council office. So ultimately, if it's on a residentially zoned property, we're not looking at it any further for compliance with other city permitting requirements, and we move forward. So we look to see if there's a license, and then we go into ZEMIS to look to see what the underlying zoning is. And if it's residential, any of the types of residential, it will not be used as a sensitive use. The information gets pulled in from the state's website, and then again, it's published on our map. If in our review, we see that something could be considered a sensitive use, then we actually go in and deep dive and do further research on the location. The points that are put on the website are just taken at face value from the different government databases. They're not individually reviewed unless it could potentially impact one of our pre-application records moving forward. So that, again, that's why applicants have to do their own due diligence, because just because something appears that it could be a sensitive use on the website doesn't mean that when we do our research and review of the actual location, it will be considered a sensitive use. And then, of course, we use ZEMIS. There's other websites. There's the open data portal that the Office of Finance publishes all businesses on. We use that for the BTRC and taxpayer information. We get Office of Finance reports through the LA tax system from finance that show who's paid their fees so that we can determine when the application was filed. And then, of course, we use different web mapping apps. So within our website, we've got all of the different locations that get toggled on. If anybody clicks on one of these sensitive use locations, you'll get more information about the location so that it can help you do your own due diligence. This is all information that we're pulling in directly from the state databases and website. We are not able to verify whether or not the information is correct. And again, if somebody who believes that they are considered a sensitive use looks at this information, and then ultimately they look to amend the information they have with that licensing or government agency, it won't be reflected for DCR's purposes until one, that government agency updates the information, and then two, we do our next quarterly update. So that's a little bit about our licensing map, the sensitive uses, and how we do our determinations. Moving on to the next slide, we'll get into the map of licensed retailers. So that's the map that we've put together for consumers. So if you were to go to the DCR homepage and you look under personal activity, we have the map of the licensed retailers. Again, folks can open up the map into a separate window if they want to be able to search. You can click on the little magnifying glass, enter an address. What that'll do is that'll tell you what the closest licensed location is within the city to your specific location. So Fig Plaza's right here where the little hand cursor is, and you can see that there's licensed businesses here, 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 here. And then we've also created an icon. The green star shows the licensed social equity businesses. So if somebody was looking to shop at a social equities dispensary, they could go to the green star, which is here and over here. So this is really a tool for consumers to identify which of the locations are actually licensed by the Department of Cannabis Regulation for the purposes of selling cannabis to consumers. And then again, this information is tied to the actual layers and the updates that we do on our retail storefront licensing map that our applicants utilize, and it gets updated. You can see the last update was October 2nd. So we're trying to update the map at least on every 30 days. And as we transition into the annual application process, we're working with the Excella team to actually automate the process so that we'll be able to push this information more frequently to our web mapping tools. We're hoping to get it down to updating it on a weekly basis and then basically getting it to update on a nightly batch, hopefully either late this year or early next year. And that's it for the presentation about the two maps. So Jen and Gidget, if you guys are ready, we can hop into any questions that folks may have.
Thank you, Jason. Good afternoon, everyone. We do have two questions so far. The first one asks, when a business does not have a license to operate, they should not be operating, correct?
That is correct.
Our next question has to do with sensitive use, and they are asking, what about places where children's programming is regularly scheduled that are private programs, including dance and karate schools?
Those are not considered sensitive uses. The only things that are considered sensitive uses are the categories articulated in the municipal code, and it has to meet that formal definition in order for us to consider it a sensitive use.
And those are the two questions that we have at the moment. If anybody wants to chime in, now is your chance via the chat. We have an individual asking about the link to the last map we saw on the website. I'm assuming that's the retail map. I'll ask Jen if she can put that onto the chat so that everybody can get that link.
Yeah, and I went ahead and dropped the two links into the chat. One is the one that's embedded on the DCR website, and then the other one is the open version in Google that allows you to enter the addresses and then toggle on and toggle off the layers. And if it's okay with Jen and Gidget, um, folks are able to unmute themselves. So if they wanted to unmute themselves or raise their hand to ask a question, we could also facilitate questions that way. Feel free to unmute yourself.
Awesome. I just had a quick question. I think you mentioned it, but I missed it. How many feet away from a sensitive use location does the dispensary have to be?
So it's got to be 700 feet away, and then it's going to come down to um, whether it's another business, because if it's another commercial cannabis business, those aren't considered sensitive uses. And the measurement is the closest exterior wall of business A to the closest exterior wall of business B. Between a commercial cannabis business and a sensitive use that has exclusive control over the parcel that the sensitive use is located on, it's from the closest exterior wall of the business to the parcel line that the sensitive use is located on. And then the third type of measurement is between a commercial cannabis business, which will be the closest exterior wall, to a sensitive use that does not have exclusive control of the parcel, which would be the closest exterior wall or fence to that sensitive use. So there are some strip malls where individual units are their own parcels, and there are strip malls where the entire strip mall is located on a single parcel. So if a sensitive use, like a daycare facility, was in the middle of it, it's not from the exterior wall of the sensitive use to the parcel line. It's actually from the exterior wall of the commercial cannabis business to the exterior wall of the daycare facility, even if it's located in the middle of the parcel.
I got it. Awesome. Thank you.
You're welcome.
Last question. I do have one more question. So if they are, let's say there is an illegal cannabis shop that's operating and they are looking to get, I don't know, a permit. Is it too late for them to get that permit since they're operating illegally, or can they still move forward with obtaining a permit?
They should still submit a pre-application review record. And then it's going to come down to whether or not there was an enforcement action taken against them at that specific location. So within the municipal code, under 10404, there are reasons why DCR may deny business premises location. So some of the things and the reasons that it's good for the council offices to work with building and safety, DWP, and LAPD on identifying these unlawful establishments, which are unlicensed commercial cannabis businesses, is that to the extent that there's a utility disconnection, DCR would not be permitted to accept an application at that location for up to 5 years. And then if there's padlocking that occurs at the location, again, that's something that would disqualify the business premises for a period of 5 years. For things where LAPD is actively working on with the city attorney's office on any type of conviction under 10415, which is what establishes an unlawful which has the definition for an unlawful establishment. If there's a conviction tied to that unlawful activity, that would also disqualify that proposed location for a period of 5 years.
Understood. Awesome. Thank you.
You're welcome.
Any additional questions? I think we're good. I don't see any questions in the chat and nobody raising their hand. Jason.
I just want to thank everybody for taking time out of their morning to come and meet with us. And then if anybody has any questions and stuff or follow up, please reach out to Jen Merkeen. She's our public information director and she's our direct liaison with a lot of the council offices. And then she'll make sure that the question gets routed to the appropriate person within our department.